And we're live, and we're back to the Judiciary Committee on continuing testimony on S89. And we're going to hear from Jared Bianchi of the State's Attorney's Office next. Identify yourself and proceed. Thank you, Jared, for being here.
Thank you again, Mr. Chair, and thank you, members of the committee. I've already testified before you on this bill once before, and so I'll keep my comments brief. There was some discussion this morning about the forensic working group, and I think that's a useful place to start. We also were a part of that working group, and our broad recommendation at that point was that there really needs to be a complete rewrite of the justice-involved components of the way that we deal with the issues of competence and sanity. But and we did provide draft language to that effect, but it's really a multi-year process to do that. And we, for all the reasons you just heard from Joanne and the other witnesses, we really need to act now to address the most acute gaps in the system. We can't ask more people to endure the experiences that you've been listening to already today. And so those same experiences and those gaps are why we've asked for the changes to the bill that we did last time I testified. I've had the opportunity to review draft number 2.2. We would say that the changes that are made in that draft are sufficient to address any suggestions that we had, and that we would ask that the committee adopt the bill as set forth in 2.2 and as quickly as possible so that we can.
I apologize. So we are looking at draft 2.3, but Panina, is 2.3, is that the one that just had some typos that she sent? Yeah, so I think it's probably fine. 2.3, from what I understand, just had a few typos. So I think you're in safe ground on that. Although I do understand, and we don't have that language, that there may be further suggestions on addressing some language that's important to the state's attorneys. I'm going to try to find the page, but 18 VSA section 7618 A2C, which has to do with asking for a discharge or hearing. Same thing with the developmental disability component as well. I'm not asking you to weigh in on that. We may be circling around one last time on that language that I believe is important to you, but if you have any other comments on the other language.
I was able to work with legislative counsel to put some of what we were requesting in just more accessible, clear language. And I really appreciate Attorney McClynn's time on that. We see that it looks as though all of those changes have been made in this most recent draft. If you're referring to the language that is at the bottom of page 11, carrying on to page 12, with respect to the hearing and the process, that doesn't raise any concerns for us. We've reviewed this draft. We think it's a strong move in the right direction. We don't have any edits that are, I think, critical to address at this time. And based on the need, we would just urge you to move the bill.
Okay. I appreciate that, and I think that is the section that may have or has a suggested additional change. Again, I will circle after. That will be after we've heard from a couple of the witnesses. I don't think it's significant. It doesn't look significant, but we will make sure you get the language.
Thank you.
Where you are with that, because we're going to have additional opportunity to testify on Thursday with any kind of final tweets and such. So we'll keep you on the list just in case you have anything more to say.
Appreciate that. Thank you, Mr. Chair.
Absolutely. Anything else at this point? Any questions for Jared at this point? I appreciate it. Thank you very much, Jared. And we will go to Matt Valerio next.
Yeah, I missed it a little bit. Was Jared referring to this draft?
We're working off of 2.3, but my understanding 2.2 just, there was. So the crux of what he was testifying on remains the same.
Right, okay, that's what I thought. Thank you.
I grabbed my glasses, so I won't be able to see.
But they had one of these back.
Yeah. I'll go down a little forward of me. Forget that I have a bigger screen when I'm in the office looking at this. So, I'm Matt Valerio, I'm Defender General for the state of Vermont, and it's never a surprise that folks who get involved in the criminal justice process, frankly, on any side, are not particularly satisfied with the process or the results. And I was on the S3 study committee. And this is the first time I'm talking about S89. And there have been, I guess, 3 additional drafts since the draft that came out of the Senate. And that's all happened since like last Friday, as far as I could tell. That was the first time I saw the first change, which was significant and concerning. But I think that it's important that I tell you a little bit about what our position was, meaning the Office of the Defender General, regarding the issues that were in S3 that we were asked to talk about, because I don't think that they've really ever been considered by anybody, to be perfectly honest. And I believe that there was significant amount of agreement on a certain number of important issues. And those have not really been addressed, in my view, by the legislation that either in S91 or S89. Without going into the factual basis, one of the things that first thing on my list that I proposed I put this in a statement that I submitted that was supposed to be attached to the report. And this was last summer, is that Vermont is absolutely in need of a forensic facility, in my view. When Hurricane Irene wiped out the state hospital, it wiped out a huge resource that was available statewide for individuals who were justice involved and who were a serious threat to themselves or others in the state. But the question always remains, and some of the prior witnesses alluded to this, is what kind of facility is this going to be? Is this going to be one that is a 200-bed facility or a 12-bed facility? And obviously the costs are huge and different. There is no place right now that really appropriately deals with the needs of the folks who are in this small group of people with very serious crimes and very serious mental illness. And that leaves everybody who is involved in the system, whether it's the victims or the litigants being the state and defense, unhappy with the results of what comes out of these proceedings. The second thing I called for in that statement regarding S3, and I think we've talked about this a little bit in context of another bill, is Vermont allowing doctorate level psychologists to opine on competency and sanity for individuals who present as mentally ill in the criminal justice system. Again, the PhD or PSYD. One of the big complaints is that the process doesn't move fast enough, and it can't move fast enough unless there's enough people to do the evaluations. Again, this issue, it looks like a small change because every other state except for Rhode Island in the nation allows doctoral level psychologists to do these evaluations, would increase the availability of people who do this work, and hopefully lessen the amount of time, and we probably would attract some people to the state if they knew that this work was available to them. The third thing, yes.
Do you agree with that? I mean, you
Yeah, it was my suggestion. It wasn't even in the bill before I suggested it in the Senate. It's absolutely necessary, and it should have happened, as soon as we could do it. It's very interesting that in our juvenile system, there's no exclusion of a doctoral level psychologist to do competency evaluations for juveniles, but the way our statute was written, in pretty much a legacy, just that it has never been changed. In the criminal system, that isn't the case. So we need that, and we need it yesterday. There is a significant backlog, although much less than it was. I asked the Department of Mental Health last week to give me numbers on how many people were, what the backlog looked like last week. And trying to find it in my log. My memory was that it was under 100. It was like 80 cases. I think it was 80 cases. And when we started working on the backlog a year and a half or a year or so ago, when the courts reopened, that number was more than twice that amount. So the number's been coming down, but it still takes 6 months or thereabouts to get an evaluation once one is ordered. And that is the independent evaluation that the court orders. So, that in and of itself causes a delay in these cases. And frankly, the defense system has no interest in delay for delay's sake, because we've got to move cases. Our normal pending caseload for a public defender would usually be 75 to 90 cases, somewhere in that range, and we're now closer to 200. And that is a direct result of the pandemic.
in a year.
No, that's pending cases. Pending caseload. The standard for public defenders is it's an American Bar Association, what's called the lawyer equivalent caseload standard. And that standard is that the average public defender working 40 hours a week is supposed to be able to handle 400 added misdemeanor cases, or 150 added felony cases, or 200 added other cases, which are usually post-conviction matters, probation violations, post-conviction relief, that sort of thing. We weight our caseload and distribute our lawyers around the state based upon how many cases come in any given county. Pending caseload has not been the standard in the past. But what nobody ever accounted for was the fact that we'd stop basically going to court and having trials for 2 years. And that's what has put us in the situation that we're in as far as the backlog. The issue with available people to do evaluations really is arose during the pandemic, when most of the people, I think at one point, the Department of Mental Health didn't have anybody on staff who was able, I think they all left, but 4 or 5 people who were doing the work left, and they had to go out of state to do this telehealth evaluation process, which by the reports that I'm having is not good. But as I've said before we have to have something, and it's what we got, so to speak, you know. I also recommended, I'm just going to move on with this. Fourth thing I recommended is that there be judicial review of Department of Mental Health decisions to release mentally ill individuals who are involved in the criminal justice system, who have been held on orders of hospitalization, whether it's on competency or sanity grounds, for a certain group of very serious crimes. I talk about that very serious crimes as being those that would have a potential penalty of life in prison. So murder, sex cases, kidnapping, certain types of arson cases, that kind of thing.
Can I ask a question about
Yeah.
this one? And folks who want to follow along, I posted this report and it's on page 11 that we're looking at the statements. But so is that a situation where the person was initially on an order of hospitalization and might be down, I'll call it downgraded, that's not the right terminology, to order of non-hospitalization, where they might end up then at the forensic facility as we're kind of trying to define that facility's intake?
Well, it might be. At the time, what I was thinking of is there's no reason why a decision of a government agency shouldn't be reviewable by the court. And it's something we do routinely across government, across many agencies. And that made perfect sense to me. I also note that the fifth thing I suggested is the Defender General's office does not oppose state and victim notification regarding community release of individuals who have previously demonstrated a danger to others. S3, whatever the act number is now, I don't remember.
Act 57.
Provided for some of that. And I don't know, however, if there were resources sufficient to implement that in the meantime.
So are you therefore also fine with the additional victim notifications that we have in S89 that we've added? That would be part of what was added, like I think last Wednesday. Is that not the same thing?
It is. It's not what I had in mind, but it is akin. You know, it's the concept is there.
Right.
And the point is that these folks, when someone's released into the community, should have the ability to understand that a perpetrator of, you know, whether it's criminal or not. And I need to try to explain this a little bit. When we talk about victim of a crime, when we talk about a crime requires certain elements under the law. And one of the elements is competence or sanity. Otherwise, it's not a crime. It's an incident where there are clearly victims, there are clearly perpetrators, but it's not a crime. So separating that concept is important as to how we treat people, how we talk about people, how we react to the situation. Any individual should have a right, in my view, to understand what threats or problems are out there potentially to them. So if somebody is a victim or a victim's family and somebody is being released so that they're out in the community generally, I have no problem with them understanding that that person is out so they can do whatever they need to do to make themselves feel safe, even if it's just a matter of being aware of what's going on. So that doesn't bother me at all. I also don't have a problem with transparency of proceedings so that they have some understanding of what's going on, or at least have it available to them. I've heard many people talk about their experiences with the criminal justice system, whether it's defendants or victims or just witnesses or jurors. They have no idea what's going on. They're just along for the ride. They're on the wave, and the wave's going to deposit them wherever it's going to deposit them. But they don't understand. And victim advocates do the best they can to explain the process. They don't always have a full picture, and the attorneys don't have time, to be perfectly honest, handling the caseload that they handle to sit down and explain the nuances of what goes on with these things. So to me, victim notification and community understanding of what the process is an important element of taking the mystery out of it. And so that people do have an understanding of what's going on. And maybe if the mystery was gone, there would be more satisfaction with the system as a whole. I made some other recommendations that are kind of more, that are less specific to the types of issues here. I talked about embedding law enforcement with mental health, people with mental health credentials to deal with mental health emergencies in the community. Talked about looking at early recognition and treatment of mental illness and expanding the available community treatment centers so that we don't get to the point where, violence and mental health are mixing to create a criminal atmosphere or creating more victims. Those are much bigger policy issues than we're going to deal with here. But I don't think there was significant disagreement, although there might have been some, with the first 5 things that I talked about. When S89 came out of the Senate, I was prepared to come in and say that I'm supportive of S89 because I think that it did fundamentally what I thought there was some agreement on. And again, there might be, I'm not going to talk for everybody because I don't know what absolutely everybody said in their statements or reports that were part of that S3 study. But I think there was general agreement of some sort of forensic facility being established. It also became very apparent early on that it wasn't going to ever be a 200-bed facility because there's no way we were going to ever be able to fund that. And it probably wasn't appropriate either. So now we're talking about a much smaller facility, and there seemed to be written into the statute some fundamental criteria for how you get in there. And we were going to use the existing mental health procedure where this facility would be a placement option available to the Department of Mental Health to do what we've always done under the statute. And I was good with that. And I thought, and I understood actually that other people were good with it too, because when it came out of the Senate, that's what they said. Since the end of last week, there have been significant changes to that bill that I can no longer support, and I would not support the bill in form 2.2 or 2.3, which by the time I digested 2.2 from yesterday, 2.3 came out today, and it might have been typos and other things that were being corrected, but I don't know that for a fact. And you've got to be careful with this stuff because you don't know exactly what's going on when these things are changed because I wasn't read in, so to speak. There are portions of this bill, and I will tell you conceptually what the issue is. This Human Services Community Panel, this is the label that has been chosen in Section 2, reminds me of effectively a civil commitment board without all of the things you need to have a constitutional civil commitment entity. And without the administrative process, both the substantive and procedural due process protections that go with civil commitment, this type of panel as created would not be constitutional. Civil commitment was considered by Vermont during the Douglas administration after another bad case, the Michael Jakes case. That was the Brooke Bennett sexual assault and homicide that occurred after Mr. Jakes was discharged from probation after completing everything that he needed to complete in a prior sex case. Civil commitment at the time was rejected in favor of mandatory minimums and indeterminate life sentences in cases because primarily of the cost. Individual civil commitment infrastructure and the process that it takes to do that tends to cost millions of dollars a year to administer. To create a constitutional civil commitment panel, it usually requires a forensic panel of medical doctors, psychiatrists, sometimes, usually, actually lawyers, perhaps a community member, somebody from law enforcement, to take evidence that is subject to cross-examination and challenge with the ability of the individual who sought to be committed or placed in a jail or a forensic facility, depending upon what the placement would be, to present their own expert evidence on their own behalf and challenge it before that board. The person who is who is sought to be placed, whatever that is, has these due process rights, both from, and there's two parts of it. One is the substance of it, and the other is the procedure of it. There is substantive due process and procedural due process that is not baked into the proposal in S89 2.2, 2.3.
So can I ask a question about
Yes.
that? So as I understand this, is the Human Service Community Safety Panel is almost like crowd control as far as which person are we going to allow into the forensic facility. But there are actually at least 4 things that need to be found by a court, or 3 things that need to be found by a court before somebody is sent to the forensic unit. And this is on page 11 at the top. They have to, first of all, there's a recommendation of where the person should be put, and that's from the Human Services Community Safety Panel, which the court presumably could look at. But there has to be an incompetence finding. There has to be that finding or insanity, and that's where the exchange of experts and all of that argument and due process happens there. And we've also added, before you put somebody in a forensic facility, that there has to be evidence that the person committed the alleged crime is great, just to make sure that that we're treating people who are going to the forensic facility equivalent to somebody who is being held without bail. That's kind of where
that in and of itself is a mixed problem. You're conflating bail law with release law under mental health process. And what the Human Services Panel does, and this is where the first issue I have with the panel, you notice who the panel is made up of? They may or may not be experts, but they're all political appointees. They serve at the pleasure of the governor. And I like our governor. I don't agree with every decision he makes. I understand that it would be nice to have all the people who work for you making decisions about individuals who you think one way or the other should be in a particular type of facility or not. But that's not due process. So that's a concern. These are not independent people evaluating the mental and medical health of individuals as to what their placement should be. It may be all fine. I don't know. But they're all political appointees. They aren't what is typically in these type of panels, which is experts, people who are recognized by their credentials in their field. So the next, and I agree, first of all, there was an initial decision about whether somebody was incompetent or insane. One of the reasons it's coming to the community service, or community human services, community safety panel. It's a lot of words. We could do that, maybe better.
Panel, we'll just.
Yeah, the panel.
The panel.
Is that they are now, somebody is determined, probably a doctor, that they are no longer in need of that highest level of hospital care, or they are now, so they're now being considered for another placement. That decision in and of itself is something that is typically reviewable, the issue of placement. This panel doesn't add anything to that process except to say that we've got political parties making a decision about where this person should be, and what they're going to look at, I would imagine, is what were they charged with, what was the and then there's a lot of provisions for victims' input and the like in the process here, but it's not a medical decision. The problem here is that this doesn't state, part of what it doesn't state here is that this person would have a right to counsel. That's not in here. It doesn't say that the individual who these decisions are being made about would have the right to cross-examine and contest the evidence that might be used to place them somewhere if they don't agree with it. It doesn't say that they would have the opportunity to hire their own experts and present evidence on their behalf as to what the appropriate placement would be. So
isn't that, I'm sorry, but doesn't that all happen for when they're seeking an order of non-hospitalization?
this is after that. I mean, this is effectively a new proceeding.
So we have the order of non-hospitalization,
Right.
They're incompetent, and now they're trying to decide whether this person should go to a forensic facility or inpatient
Right.
hospitalization or the secure residential.
Right. And say you're the person, the individual who people are making this decision about. You don't want to go to a forensic facility. What's your option? You need to be able to present your case and say, hey, I'd be perfectly fine in the community with a peer mentor or a social work staff or whatever it is to assist in making, I'd be better off at an order of non-hospitalization with various conditions and various supports in the community as opposed to placement in a forensic facility. That is not discussed in the bill. But this was written by one side of the fence, not the side of the individual who is the subject of the placement. All I'm saying here is we need to be able to provide individuals with the opportunity to be heard on their own placement. If the decision of the department is not what people want to hear, then that decision goes to court. And that is reviewed. That's a review of government action, which is something that is typically done, again, across the state in all kinds of matters. We do it in the Department of Corrections when it comes to decisions that they make. We do it in all kinds of areas in government.
So let me just ask one other question on that, and then Joe has a question as well. Again, I keep on jumping to page 11 and the additional steps that we have. If the commissioner determines the treatment at a forensic facility is appropriate, then the court still has to make findings that it's the least restrictive setting of adequate, that the person is presently incompetent or was found to be guilty by reasons of insanity, and that the evidence was great that the person committed the crime.
And what's the panel doing?
Panel is presumably making the recommendation and going through other information to inform that decision. So
what it looks like to me is that The panel doesn't trust the doctor or the Department of Mental Health, and they're there to make a recommendation that is to try to keep that in check. And there is no process for the person who's the subject of the placement to have any input on that.
Right, okay, I see. Joe, do
So-
you have a follow-up on that?
Yeah, I just, because it seems to me, and this is page 3, lines 8 through 11, it seems to me that the purpose of this panel is to inform either the Commissioner of DMH or Dale's decision of and whether to seek placement of the person in a forensic facility. And then that ultimately also has to be a decision then made by the appropriate commissioner in order to then trigger the hearing under, 1876, or, whether it's the Dale or the, or the DMH procedure, whichever it is, but the non-hospitalization order, which then goes through the, which then has the actual hearing. And sort of the analogy, and I know this is a poor analogy, but the analogy that was imagining in my mind was sort of like a grand jury in a way, where sort of like the prosecutor is getting to give all the information just to reach a standard of like, yep, we're going to charge, and the defense really gets no say.
Yeah,
and
that's exactly what I saw too. That was a concern.
And so I guess just, when.
Because what they're doing in those proceedings, as maybe you know, I don't know if you've ever done one of those.
I've never been in the.
But the evidence that is taken in those is just that evidence. You're not looking at contrary evidence. And the real issue is, do we charge or not, based upon just seeing one side of the case. In this, you've actually got a panel that's comprised of two of the people who would ultimately make the decision about where the placement would be, informing themselves about where the placement would be. You have the Commissioner of Dale and you have the Commissioner of Mental Health being on the panel, and they all work for the person who's the secretary of the Agency of Human Services, all of whom are appointed by the governor. I don't understand what this adds, and it concerns me from a constitutional standpoint. So, it is, again, I had, until this popped up in one of these drafts, I was perfectly fine with S89 as it came out of the Senate. Because I think what it did is use the system we know to make a determination about placement. And then it established in the last part of that bill, of S89 as passed by the Senate, particular criteria that would be considered when making that decision. And that is not, among other things that I will get to. As you go through this, the notice and procedures and the like, there's no discussion about. There's not really even discussion about notice to the person, notice to the person's lawyer, the right to counsel, all of those things. This was just written from the prosecution side of things, so to speak. And I don't mean, because they're not prosecutors when they're at this level. I'm just not looking at it from the legal representative side of the person who sought to be committed. Some of this also suggests that if particular findings are made in other spots, the court is compelled to make particular placements. I'm trying to, this thing grew quite a bit and my notes are on the side. think I guess assumed.
Yeah, Karen has a question.
Yes, sure.
Thank you for this, and getting a couple to get more perspective, because my understanding was this was what was in the section that's now removed, section 18, the rulemaking. So you were supporting this when all of these decisions were going to be made during the rulemaking procedure, right? Because my understanding is that this language that we're looking at here with the panel and such is to take place of the whole rulemaking, the admissions criteria for a forensic facility.
I didn't see any criteria for that, aside from the 4 elements, I think, that are at the end of S89 as passed by the Senate. Those were the primary criteria. The rulemaking was to establish the procedure to implement that. And so that rulemaking is something that we would have participated in, and I'm sure legal aid would have participated in, and the advocates and the like, really to establish the procedure surrounding the forensic facility. We didn't know what that was going to be. They were going to write rules, and then they would be subject to publication and comment and the like, as we do with any kind of rules that arise out of this. Arise out of these bills. But I guess I'm guessing what they attempted to do on pretty short notice is to write a bunch of stuff that they would have wanted to put in the rules into this. But it looks to me like they did it pretty quickly and without like a full view of what's going on. And so from what I saw before, yes, I was supportive of it. If it had all this stuff in it, probably not. But that's something you work through in the rulemaking process.
So is there a recommendation to go back to the rulemaking? Your preference would be that it goes through a rulemaking process?
I would accept S89 as it came out of the Senate, and that included the rulemaking process. Rulemaking process would have, I would imagine, I mean, I can't imagine not, provided for right to counsel and present your own evidence and all of that kind of stuff, to the extent that you don't agree with the decision of the department. The other part that I wonder about this, now I might be making this argument on behalf of legal aid, and they represent the people after the decision is made to that somebody is incompetent or insane, and then the hospitalization process or non-hospitalization. And they would probably be litigating this, not the Defender General's office, but it stuck out to me from a substantive and procedural due process standpoint that I felt like I had to bring it up because I was more than willing to accept S89 as it came out of the Senate, and looking at this, I could not support it.
If I can add one thing, I'm just trying to get context, because I am not remembering when this new language came in. Like, I remember it was a conversation of like, oh yeah, so we're going to take out rulemaking. We basically kind of did this here. I don't remember, was it a timing? I'm just trying to get the context of why we switched from rulemaking to this. I feel like there was a timing. I feel like that's where we can find where's the middle ground that we can work on with it.
Well, I mean, I would just suggest don't worry about the middle ground, find the right ground.
Usually it's the middle ground, I feel like.
The middle ground often gets you in a lot of litigation. The right, if you stick to giving people a right to present their side of the case in an appropriate forum, then there's not a lot of litigation involved. Then you're just arguing about the substance of, is this person appropriate for a forensic facility, or are they appropriate for something else? What is the placement? And that kind of argument is the argument we make all the time. That's the kind of argument legal aid makes all the time. And we have a system that's been in place for decades that has been working in general for decades until our system over the last couple of years became broken when the hospital washed away and we had 2 years of no court. What I'm hoping is, I don't have any great hopes that we're going to rebuild what used to be the state hospital. I do think that at some point we're going to get out from under this burden of the pandemic. And we're going to start getting, turnarounds on evaluations in, 30 to 60 days instead of, 6 to 8 months.
So let me ask a kind of more fundamental question on this. Should we be relying on this rulemaking process to get the due process rights of these individuals correct, or is that really what we should be doing in this room right here? Should we be delegating this component, even though I know it goes through LCAR, but
Yeah, I think that would be a great question when I was getting my political science degree from St. Mike's 40 years ago. That's a question. I will say honestly, I don't think that the legislature has the particular expertise necessary to do the details of trying to write the rules into the statute unless you, God forbid, created another study committee that specifically was designed to create a process. I don't recommend that. We've got plenty of study committees, and they, often end up with either very strange consensus or lack of consensus. So, this is one of the reasons you have rulemaking is you're leaving it to experts in the field to make sure that it is done the right way. And I feel like this is rushed. I feel like this was we had a bill that came out that looked like it set the framework for what we want to accomplish. And then the rulemaking was going to take care of the process, subject to the criteria that was in the bill in S89. When we started to do the rest of this in here, that's when it caused a problem for me.
and just to make sure, as far as what I have as far as the big two issues you've raised with respect to this, and there's probably more, but it is the basic due process, but representation in this process, the opportunity essentially to be heard, opposing the recommendation or coming up, and then the political nature of who's
right. What I would do is I would eliminate the panel. I would then give I would go back to S89 and then rely on our current statute and put where you are, whether you're in a forensic facility or not, is an argument that is made as far as placement, subject to our existing law.
So I think we've got that. Now I just have a more, because there are other changes that we have in here that are not directly related to the Human Services Community Safety Panel, which is different than what came out of the Senate. And again, I'll point you to page 11 and the various changes there. The top one I've already mentioned a couple times and certainly wouldn't mind having your comment on that. And then getting into the ability to request and have a discharge hearing. So it's really a victim, victim oriented as well. So if you have input on what we see on page 11 and 12, it'd be appreciated.
I do. I've run this by my appellate division. They believe that piggybacking prior findings on regarding basically incorporating a weight of the evidence hearing bail decision into this process would be unconstitutional because you're not looking at the same factors or facts relative to placement as you would when it comes to placement and jail. What I have here is what has been relayed to me, and I understand the logic of it, is that a person can at any time has a constitutional right to review bail upon a change in circumstances. That can happen at any time. And in this, it's actually incorporating prior findings where there would be obviously a change in circumstances that should be reviewed by the court. And what this, if you look at sub 2 in the green language, this is where I could tell a prosecutor wrote this, because what it does is incorporates bail language into this forensic facility.
So a prosecutor didn't write that. It was actually my suggestion and Joe and working with legislative counsel. But let me explain why.
The prosecutor in just
I try to have defender in me. I defended the government for 13 years. I didn't.
no such thing as defending the government. The government is the government.
Fair enough. So here was the rationale, and it is that you could have the same individual who, a violent individual who's one could find is a danger to themselves or others, who doesn't have a criminal charge against them. And then you can find the same kind of person that has a criminal charge against them. The person with the criminal charge can go to the forensic unit, not the person without the criminal charge. And if you're going to the forensic unit, and if you jump way ahead on page 31, there is a proposed rulemaking that would allow the use of emergency and voluntary procedures in the forensic unit. And from what I understand, that's harsher restraints, essentially. And so we wanted an extra step before you decide that you can put somebody into the forensic unit that has these harsher restraints. You need to have a little bit more. You need to, and that's where this language came from, to try to address that. Joe can explain if I was right.
No, I think you're right. I just wanted to piggyback onto that, because I think the concern that we were working around is that, but for being accused of a crime, this person would be going to the secure residential unit, and in the secure residential unit, they can't use these harsher levels of restraints, and they can't use involuntary medication. And so the concern, I was a little surprised here, this might be unconstitutional, because I think the concern that we were worried about was that here you have two people being treated differently simply for one simply was being accused of a crime. There's been no constitutional, no due process for that person who's been accused of a crime. It's just like, you happen to be arrested for this behavior. Therefore, now you can have involuntary medication and you can have harsher restraints. And we want to do what could be done to ensure that if we're making a decision that someone's going to be placed in a particular facility due to criminality, which is the distinction here, then there ought to be some sort of protection to ensure that there is some evidence that the criminality actually occurred, so we could justify them being treated differently.
Is there a hearing?
Yeah. So if you look at page 11, yeah.
Okay. I will say this, and this was a note that was provided to me, and I'm not blaming them because I saw the same thing. This was enough confusing to our appellate division that it caused concern. So there might be a better way of saying what you're trying to get at. And there had already been, if the commissioner determines that treatment at a forensic facility is appropriate, and then the court finds that the treatment at the forensic facility is the least restrictive setting adequate to make the person's need, what does the next, still not getting what the next part adds, because that determination already has been made by the first two sentences. Wait, so we're going to have we call them weight of the evidence hearings. A hearing on whether or not the evidence of the crime is great.
That I think was the intention of that we were trying to do here, is to say it's basically to create a firewall, I guess you could say, between the decision of the commissioner that a forensic facility is best, and because it's a shall order standard, the court shall order the person to receive treatment there for a period of 90 days. We, I think, wanted to ensure that there was some sort of firewall between the commissioner's decision and the court order, just to ensure that the forensic facility is appropriate because being in a forensic facility is necessarily due to an allegation of criminality.
And there'd also have to already have been a finding of incompetency. Right. So that means that the charge would have already been there and there would already have been probable cause found. Or if the person is not guilty by reason of insanity, that means effectively the person admitted that they did it, but they were suffering from mental illness at the time and were not responsible as a result of that mental illness. I don't know where the weight of the evidence helps anything. I think this was clearly confusing to our appellate division. So I would suggest that it be reworked in some way. And then it also requires, it's like it doesn't say that the court may order the person to receive treatment for 90 days, or it shall. This is, maybe it's more confusing than it is unconstitutional. Either that or it's terribly unconstitutional and perfectly clear. It doesn't seem to work, let's put it that way. And it's hard for me to draft while I'm looking at it here. And I appreciate you bringing up where this came from. I don't know that it does what you hope it does. I don't know that it adds anything.
Right. But if that's an important hurdle to have in some manner, certainly would appreciate any input on how you do it.
To me, if probable cause has been found and somebody is not competent to stand trial, that means they're not subject to the jurisdiction of the criminal court. And the next issue is placement, and that's the argument that legal aid makes all the time. There was no order, non-hospitalization order, hospitalization order, forensic facility, whatever it is. If somebody is not guilty by reason of insanity, the issue of weight of the evidence is not particularly relevant because they effectively have admitted the crime, admitted that the incident took place. So this is the whole thing, the semantics of crime, admitted what occurred, but that they were not legally responsible for it. So, I mean, I can.
Go ahead, Joe.
Yeah, I wonder, given that certainly I think we were talking about this, we were thinking about due process and defendants and everything like that. Do you feel satisfied that the initial finding of probable cause is sufficient to address the concern that we're expressing here? Of that we just want to be sure that this person ought to be treated more harshly, again, because there is an accusation of underlying criminality, the way that they would not be treated in the secure residential facility. So, because you said you were happy with the Senate version, which didn't include this sort of enhanced language. So I guess so you feel satisfied that we don't have a due process concern about the treatment of the individual differently?
Well, the due process comes in the findings that the court is already making, that the person, that treatment in a forensic facility is appropriate because the court has found the forensic facility is the least restrictive setting, adequate to meet the person's needs. That is the law currently for any placement. And the issue really in this paragraph is how long should they stay there before it's getting reviewed. I think the part that is highlighted in green on my screen, I think you got green too? Okay, that's good.
Super legible.
To me, clearly it confused everybody. If it came out, I don't think it would be a bad thing. I don't think I just, given the other findings that already have to be made, I don't think it adds it. And I do understand and I appreciate your concern that, but once you get to this level of we're working on the mental health issues of the person, and this is the least restrictive setting adequate to meet their needs, I think that satisfies what you need to satisfy. As I indicated, probably in general in my statement regarding S3, Act 57, is that I don't have a problem with notification to state's attorneys and notification to victims when individuals are going to be discharged from facilities or from orders. And if nothing else, just for clarification of the process, understanding the process, and being aware of their own safety if they feel that they're not safe.
So you're okay with the additional language on page 11 where we're trying to get at that?
Yeah, the concept for sure. The notification to victims and state's attorneys and attorney generals is fine with me. In the event that if you're going to have a hearing objecting to it, however, this is another portion.
Yep.
Where it says that the state's attorney or attorney general and the victims are entitled to speak and appear, provide their opinion. The prosecutor may call witnesses to present evidence. What about the other side?
That's not implied?
I don't think it's implied unless you write it.
Okay. All right.
So, the person should have the right to counsel. They should have the right to call witnesses and present evidence on their behalf as well, if that's going to be contested.
Can I ask a question about this section, even though it's probably not a question for our Defender General? I'm just curious if line 4 and the victim, does the definition of victim include a victim's family? The victim
I do believe it does.
It does, and I know this stuff.
Well, I know, I'm sure you know it.
No, well, we deal with them.
Walkthrough question.
No, we deal with them all the time. I mean, we probably know better than ledge counsel on these things. That victims include family members as well, for sure.
So on that page 12, I have a note to make sure we have the process for the other side as well. But how about subdivision D, as far as the retained jurisdiction, the criminal division retained jurisdiction?
Yeah, this is a weird one, and I had this discussion regarding the other bill when we switch a bill from being when we switch a case from being a criminal case to being a mental health case. This sort of just declares that there will be jurisdiction over a case that doesn't really exist. And to me, this should all be part of the hospitalization orders or conditions that are in a order of non-hospitalization that are enforceable and should be enforceable. And it, again, goes to one of my suggestions that the Department of Mental Health should have a more robust ability to monitor people who are subject to these orders in the community and to bring violations if necessary, so that they can get people back on track with their medication, or if they are required to, if the only thing they can do is put them in a secure facility until they can get them stabilized again, then that's an option under the mental health law. I don't know, one of the things that happens, and it is, I found the description of this odd from some prior witnesses, that you have somebody who gets found incompetent on a Friday, and then they are out in the community and they get arrested for another crime or something, and then they get arraigned again. It's like, well, and they're entitled to another competency evaluation. Well, yeah, if you charge them, they are. But didn't we just find them incompetent like 48 hours ago? This does happen all the time. It's a total waste of money in the criminal justice system. This should be a mental health case at that point. This should be like, this is a person who's acting out in the community And we have to make a determination about where we can put them in a least restrictive environment so they can't continue to do things that would put them at odds with the criminal justice system. We've already found them incompetent as a result of a mental illness. Now on Monday, we're back in here doing the same thing. This should be part of the ongoing proceeding that is part of mental health. So I have a conceptual problem with continuing jurisdiction in the criminal division when there's already a mental health case. If what we call conditions of release in a criminal case are incorporated as part of the order of non-hospitalization, then it can be dealt with there.
So in the cases where we utilize mental health court, and I don't know how much we are.
Oh, we have one in Burlington.
Would those cases be referred there, and or the outcomes, like, does it go down a different path, and is one of the answers more?
Yeah, I think those are different kinds of cases than
Okay.
what we're talking about.
So this person that you were given the hypothetical for
Right.
would not be appropriate for, well, it depends on what the crime is, I suppose, right?
Well, yeah, whatever the criteria is for getting into mental health court, they tend to be lower end offenses, more of the nuisance type offenses
So not the.
tend to get in there. It's not, yeah, and the other thing that I've talked to various folks about is that, again, we should be focusing this, because we're talking about a forensic facility, on these most serious crimes, not the ones we're not talking about. This is where we kind of start to mix apples and oranges when we're talking about the people we're dealing with. And the if you work in the criminal justice system for a long period of time, you look at certain people as like the really dangerous, and then you've got this kind of middle group of people who are the middle group of people, and then you've got the nuisance people who are on the kind of low end of the system. The mental health court tends to deal with the low end.
So that wouldn't have helped in the Bennington, because in the Bennington case, like we heard, this person has committed some pretty egregious public safety crimes and
Yeah.
is out and about.
I can't talk about the Bennington case because it is a pending matter.
Okay, sorry.
So isn't this subsection or subdivision in page 12 to make sure there's a easy transition or transition from where the case is in the mental health or under the Department of Mental Health jurisdiction, and then it's jumping back over to Department of Corrections? We don't want to have a situation where any kind of without holding, without bail or conditions of release are not there once the person is transferred back to DOC.
Yeah, the interesting thing is when a criminal case is pending, the conditions of release apply even if you're in a facility as a matter of law already.
Right.
So what I read this as saying is it takes away those when a person is discharged from a forensic facility to a correctional facility, the custody of the commissioner, custody commissioner shall cease on. No, that's not what I was looking at.
So line 10, it says that they shall
Yes,
remain.
that's already the law.
So it doesn't hurt if we have it here as well.
Just try not to confuse things. I don't know that this. I don't know this helps anything. Again.
All right. Okay. All right.
And I guess that just in summary, I think you get the point of what I'm trying to talk about here, is that, the point is that the first bill as it came out of the Senate was simple. And it worked with existing structures. And this facility placement was an issue that would be taken up in the normal course when you're talking about orders of hospitalization. Trying to put the rulemaking in here confuses things, and I'm concerned about the panel, as you said, as I said, being political, not being what we tend to see on these types of panels that involve civil commitment. And as a result of its lack of impartiality, it would give rise to constitutional concerns.
I do understand that a lot of what we talked about is kind of repeated in the Dale portion of this. So
Right, it's the exact same issue, just with,
Gotcha.
right?
Any other questions?
Yeah, I got one.
Yeah, Tom and then Ken.
All right, this one's been kind of burning in my head for a little while.
Okay.
You can probably answer it very easily. Well, when they're arraigned in court and they determine that they're going to need a evaluation, competency and a sanity evaluation, and they issue a order for that, state hospital, and they issue a MIT at the same time because it might have been some significant crime. Are they getting credit for time served at that point?
Yes.
Okay, so then the findings that the court made to put them in the state hospital and issue the MIT, do they still follow, say, the same hold without bail rules, what is it, 75538 or whatever the heck it is?
If somebody is, if there's still a pending criminal case, and somebody is held in a secure facility, they're still getting credit, and they are still subject to the
same bail restrictions under the hold without bail and all?
yes.
Okay, there was one. What's the burden of proof for that hold without bail standard? That arraignment.
Yeah, more likely than not.
Okay.
It's basically preponderant.
Yeah.
It's not.
Open for interpretation a little bit.
Yeah, it's by no means the beyond a reasonable doubt. It's just enough to keep us in court, you know.
Ken.
I apologize for being out and missing most of your testimony. Did I kind of just hear you say the way S89 came over here from the Senate was fine and we messed it up too much?
That's what I said.
I think you said it much nicer than what you
But
did.
something like that.
In a nutshell.
That's the Reader's Digest version, as they say.
That's what I like about Matt and I. We just. Perfect.
Is that all?
Thank you.
All right, thank you, Matt. And thanks for your patience, and took a while to get you in front of us on this.
Yeah, I mean, part of it is me as well, because things are pretty crazy out there right now.
Yeah, understood.
Are they
Yeah,
sane?
I wouldn't say that.
they're
Can they stand?
we like to use the word chaos around here.
Okay, I just wanted to see if
I'm
I
just-
had insanity.
I'm not talking about like anything legal. I'm just talking about the vernacular. So it's,
Okay, all right.
We'll hear from Rachel Seelig next. Thank you for being here.
Thank you for having me. For the record, Rachel Seelig, I'm the director of the Disability Law Project at Vermont Legal Aid, and I appreciate the opportunity to come in and talk about S89. The perspective I bring to this is that the Disability Law Project is who is court appointed for the judicial reviews of individuals who are committed under Act 248. So this is the Dale section of S89, which I think hasn't gotten a ton of attention. I think most of the attention has been on the mental health side. It's a much smaller number of people who are committed under Act 248. I looked at our records and it's been about 50 people over the last decade. I think it's about 25 to 27 individuals currently committed under Act 248. I want to give you a little bit of the history of Act 248. So we're going to go back in time a little bit before I talk about the significant concerns I have with S89 for people with developmental disabilities. So Act 248's history really is pretty inextricably linked to that of Brandon Training School. Brandon Training School was authorized in 1912 by the state legislature as what was then called the Vermont State School for the Feeble-Minded, and opened in 1915. It became the Brandon Training School in 1929. And by the 1960s, we had more than 600 Vermonters relegated to that institution. In 1978, the legislature created what we now know of as Act 248, as the Brandon Training School Statute. And this was to create a process, an actual statutory process for the first time to allow for judicial review of people who were still placed at Brandon and wanted to leave. So the very next year after the statute was put into place, Vermont Legal Aid filed for judicial review for a number of individuals, including one of the students at Brandon named Robert Brace. And that litigation led to what is known as the Brace Decree, which called for the progressive closure of the Brandon Training School over the next decade and moving individuals with developmental disabilities into community placements. And the training school took a little more than 10 years to close it and ended up closing for good in 1993. The standard applicable for commitment to Brandon informs the standard applicable for Act 248 commitment today. At that point, when Brandon was still open, the standard was that the respondent posed a danger of harm to himself due to inability without appropriate supervision and the assistance of others to satisfy his needs for nourishment, personal or medical care, shelter or self-protection and safety, so that it is probable that death, substantial bodily injury, serious physical debilitation, or disease will ensue unless appropriate treatment or rehabilitation is afforded. So I think what's important to understand about Brandon is that we were being what I think we can all call fairly paternalistic towards people with developmental disabilities, kind of assuming that they would not be able to take care of themselves and therefore their lives would fall apart and they would die. And when somebody was found to meet that standard and placed at Brandon, they were actually placed in the commissioner, in the custody of the commissioner. Different name of the department back then, uses words that we don't use today. And the commissioner was then responsible for placing that person in a program, an individual program. And you've heard the term a lot, in the least restrictive environment consistent with that person's need. In this case, for custody, care, or rehabilitation, for either an indefinite or for a limited period. And at that point in 1978, part of that process was also to look at, is there a less restrictive option that we could place this person in than Brandon, right? This was the goal, get people out of Brandon. But as time went by, after the Brace Decree, one of the kind of areas of what was determined to be a gap in the system popped up. And so in 1988, Act 248 was passed. So it was like 9 years after we agreed to close the school. There was this new process of Act 248 to commit people with developmental disabilities who were not competent to stand trial for serious crimes. And so, but at that point, we were moving towards deinstitutionalization and the voluntariness of accessing community-based services, right? And that remains the case today. Most people who receive developmental services, other than these about 25 people, do so voluntarily. They are asking for the services, they want the help that they receive. And to be clear, about 250, I think, people with developmental disabilities are eligible for public safety funding. So more people than just those who are committed under Act 248 get services under the public safety priority for the whole developmental disabilities system of care. And so what happened with Act 248 was there was this framework for individuals who posed a danger of harm to others, right? So previously with Brandon, it had been danger to yourself. Now we were at the place of danger of harm to others, would be placed in a designated program to provide appropriate custody care and rehabilitation, right? So same package of types of services as Brandon and as community-based services, but instead of because of risk of harm to self, risk of harm to others. And even though the Brandon Training School statute was repealed when the school closed, those elements were not repealed. And so that is what we still use today in the context of Act 248. But one of the things that I think is really important about Act 248 is that it was written so far into the deinstitutionalization process that the expectation was not institutionalizing at Brandon. The expectation was that we would find designated programs for individuals in the community. And I think this is reflected in a few different parts of the existing Act 248 language, including that it wasn't, even in 1988, it wasn't written so that these cases would be heard at the Brandon unit of the court system. They would be heard in the units where people were residing. And the expectation was to be looking for those less restrictive placements than Brandon, not assuming Brandon, but then looking for less restrictive placements. So in that sense, Act 248 has always really been oriented as being a community-based treatment and habilitation program. And it's been very effective for a long time. People are not placed in incarcerative settings, but there are still very significant limitations on their liberty to ensure public safety. Treatment teams decide where the person lives, what services they must accept. So it's not voluntary, it is mandatory services. And they get confidential information about the person from others. So you do lose that privacy protection. And the sentence, the time that someone is committed under Act 248 can actually be longer than the sentence the person would have experienced had they been competent to stand trial and then sentenced. Lots of different pieces that treatment teams can do. They can require counseling and other types of therapy. They can require attendance at medical appointments, taking medications. They can limit access to activities and visitors and locations the person is allowed to go. They decide on contact with family and other people and whether that's a supervised or unsupervised contact. They decide if the person needs 24/7 eyes-on supervision or less. So there are folks who have been committed to Act 248 where it's not just eyes-on supervision, it's like arm's length supervision, right? Like they're never farther away from a staff person than I am from you, right? The person is always subject potentially to search of their home, including their bedroom. So again, that loss of privacy. They can be restricted in access to social media and the internet. The team gets to decide if they can have access to guns, knives, other things that can be used as a weapon. They can be restricted in their access to alcohol and prescription drugs. We've been able to serve these people in the community. And I think kind of my broad theme for you is we would be taking a huge step backwards to say we can't serve these people in the community. We need a forensic facility for them. There's a pretty successful model in one of the designated agencies where a couple people who are committed under Act 248 live in the same housing unit. And it's not the easiest thing, right? Like they do kind of get on each other's nerves, right? But they live in the community. And I think what we would see is that it would actually be harder to treat this group of people in a facility where there's even more of that, like person on person, like ramping each other up, right? So for most people, I also don't think this is going to be their least restrictive environment. And I really worry that creating it as an option is going to make it easier for the state to decide, you know what, we can put 6 people here and staff this, and that'll be easier for us. And so we're going to do that. And so that gets to the Olmstead issue. And it sounds like you all are hopefully familiar with Olmstead at this point in the process, but I'll just kind of briefly talk about that case. It does not involve involuntary commitment. It does involve people, 2 women down in Georgia who both had mental health disabilities and developmental disabilities. And they voluntarily went to a psychiatric hospital. They received treatment. They were ready to be discharged to the community and they wanted to access community-based living and supports, but they could not be discharged. They remained institutionalized because there was nothing for them in the community. And so they finally sued under the Americans with Disabilities Act and said, this is a form of discrimination. You're segregating me from the rest of the population of non-disabled people by only saying I can live in this psychiatric hospital. And the court held in the United States Supreme Court held in that case that public entities like the state of Vermont must provide community-based services to people with disabilities when three things happen. One, services in the community are appropriate. Two, the affected people with disabilities do not oppose community-based treatment. And three, community-based services can be reasonably accommodated, taking into account public resources and the needs of other people with disabilities receiving services from that entity. So in the case of folks who have been committed under Act 248, we know community-based services are appropriate because we've been providing them successfully since the inception of Act 248. We have never had our Act 248 clients complain about having community-based services and ask us to go to an institution. Not something we've ever experienced. And we know that these can be reasonably accommodated considering state resources because the needs of these 25 individuals and others are able to be met using that public safety funding within the developmental services system. So I would also argue that for this population of people, there is no one who would have a forensic facility be their appropriate least restrictive environment. And so I would really strongly encourage you to remove folks who are committed under Act 248 from consideration of this if you move forward with it. I think my colleague Jack, you can talk about why it's generally not something that legal aid overall would support. If you are going to move forward with it, there are a bunch of problems with the language changes to the Act 248 sections. And I'm happy to run through those, although I am cognizant of time and that Jack's been here all afternoon too. So I'm wondering if you might prefer that I send those to you by email and copy Katie, or if you'd like for me to walk through them or pause to answer questions.
At this point, if you could send them.
That's what I think.
And we may have more time. And there's, frankly, the more we look at how much needs to be done potentially for what I will call the Dale section, the DE section, the more I'm starting to be inclined that we take that out of here and have that work continue into next session, frankly.
That would be my strong recommendation.
We've been working on it, and it sounds like we haven't gotten it right. And, so there is the fundamental question of whether it's even needed, although we have heard testimony where there's been just a couple individuals over the last couple of years that would perhaps with developmental disabilities be sent to such a facility. But if you could send that to me, that would be very helpful, and I appreciate that. So.
Absolutely. All right.
Any other? Oh yeah, Angela. Yes, questions. Yeah.
So I'm picturing that chart, the levels of care that was shared with us by DMH. And we're told that this forensic
different level of care system for developmental services.
So that gap that was identified, we need something between here and here, does not exist, it sounds like, for the population that you're talking about.
Yeah, so there has not been an institutional setting for people with developmental disabilities since we closed Brandon in 93, right? So that has not been an option. We have had a very small number, and Julie, you probably would know this better than me, number of people who have needed an institutional level of care and have had to leave the state to receive that. Until the beginning of the pandemic, we did also have what's called an intermediate care facility for people with developmental disability. It's called Westview Court. It's been run by the Rutland County, Rutland Mental Health System. That closed early on in the pandemic. That served 6 individuals who both had developmental disabilities and significant medical needs. That has not been replaced. But the other thing that I would say is one of the things that is going on because of your colleagues in human services is a lot of work on expanding housing options for people with developmental disabilities and creating kind of a broader spectrum of what those housing supports can look like rather than what we have primarily right now, which is a shared living model. A lot of people under Act 248 may be under that model or a staffed living model where staff come into the house.
Hi. Brattleboro Retreat you have anything to do with that place?
No, I really don't.
Okay.
That's more of a Jack.
There's no disability
So one of the challenges that we actually have in Vermont for people who have both a mental health disability and a developmental disability is that they may not, even if they're seeking voluntary mental health treatment, they may not be able to find a board that is willing to accept to get that inpatient level of care because of the complexity of their autism or their intellectual disability.
Thank you.
So the sections related to Act 248, were those in the bill as introduced, or were those brought in later? I haven't looked back at the bill as introduced. No.
I have to apologize. I don't know the answer to that question. This really did slip by me in trying to wear the two hats for legal aid this year. And so when Jack let me know that this was on your schedule, I asked to be able to come talk to you, but I don't know if those were included. I believe Stuart is on remotely. I know that those changes were something that Dale had been interested in. We talked to them about it somewhat preliminarily, but we hadn't had kind of a meeting of the minds of what reform to Act 248 ought to look like. And I think with some additional time, we could get closer than where I think we are between what's in the bill right now and what we think that population would need.
Appreciate that. Thank you very much. Yeah, it does look like it was in the bill as introduced, but okay, so we will go to Jack, and I know that we might be losing a couple more people, Jack, but we're going to just keep on plugging away at this. I'm not going to send you away yet again to be coming back later, so.
Well, thank you. Good to see everybody. It's, for the record, I'm Jack McCullough, Director of the Mental Health Law Project. And it's kind of a funny thing. I was testifying on this bill, I don't think in this room, I think in House Healthcare last week, maybe it was here, but we got interrupted when it was here when the building was evacuated. Right. And so I figured, well, that's fine. I've got all my testimony all figured out. I can just pick up where I left off. And now, totally new bill, or
We need another evacuation.
substantially new bill. Yeah. I agree with a lot of what Matt Valerio said, and so I will point out the one thing that I do not agree with, which is, this forensic study was clearly a failed effort. We had a lot of people coming from different directions. I think there was a hope that that we would be able to come out with proposed legislation or some proposed plan to address the problems that have been identified, and clearly it didn't happen for a variety of reasons. And we even got an extension of time to a whole nother year to give us a chance to try that, and it just didn't happen. I think the point that I started to make last time, which I still agree with, is that I don't think there's been a showing that we need a forensic residential facility. And the part of the reason for that is that the people who are in the custody of the Department of Mental Health are people who have already been determined by a court to pose a danger to themselves or others. And so essentially what we're talking about here are people, they need to make a showing that they're a danger in order to even qualify for to be in this forensic facility that is being created. And we already have, if you're in the Department of Mental Health custody, you already qualify for that. The level of, yes.
So I don't want to keep us here all night, but the people that are already in the system, I'll say, we know about them. This isn't about the ones that are already in the system so much as the ones that that need to be go through the process to become part of the system, right?
No, I would say this is people who are already in the system, and it's just a matter of where they're going to be. if you meet the criteria of showing that you've been found incompetent to stand trial or not guilty by reason of insanity, and because of your mental illness, you pose a danger to yourself or others, those are the people that we're representing in hospitalization hearings in the criminal division of the Superior Court now.
So backing up to what I think you said is they're already in the court system. Who made the decision for them to go into the court system for their plea of, because we know years ago, in fact, we're still dealing with it. We had 3 high profile cases in Chittenden County, right? How would those get dealt with? I mean, who makes that determination? We know what happened with that. I think we're trying to avoid that. I would assume you would be trying to avoid that.
Well, my project is appointed by the court to represent people who are charged with a crime and then are found either not guilty by reason of insanity or incompetent to stand trial.
And who's doing that determination of?
The criminal court is making that determination now. There's a forensic evaluation done. There's a report filed, and based on that report, the court determines either the person's competent or the person's incompetent.
And those are state psychiatrists or something making that determination?
There's psychiatrists that contract with the state, yeah. And so they make a determination. A lot of the time in those cases, if there's a determination by the psychiatrist that the person is incompetent, there's an agreement between the state's attorney and the defendant that there'll be a finding of incompetence. But there may also be a hearing, and the court will have to hold a hearing to determine if the person's competent or not. And if the person's found incompetent, then the next step is what's called a hospitalization hearing. And that's the point at which the state has the burden of proving that the defendant meets one of the standards under Title 18 under the mental health law, either a person in need of treatment or a patient in need of further treatment. And if they prove that at the hospitalization hearing, then the person can be subject to an order of hospitalization or an order of non-hospitalization.
Thank you.
You're welcome. So the level of danger, my point of going to this is the level of danger that the person may raise, the person may have been determined to have, may have nothing to do with whether they were charged with a crime or not. It depends on their mental illness, their proclivity for violence, and what they have done in the past that demonstrates their level of danger. And so, as much as we've heard in all these legislative hearings, and as much as we heard in the forensic study group, I don't think we've heard any evidence of a person who was committed through the criminal process and then later did something violent because we did not have this forensic unit available for them. So that's one reason that we're concerned about even creating the forensic unit. Another reason is that this proposal takes 9 hospital beds offline. And we still have people waiting in emergency departments to get into the hospitals, both involuntary and voluntary patients. The numbers have gone down, but we still have people waiting in emergency departments. For the last several years, we've had the Department of Mental Health and the hospitals clamoring for the creation of more hospital beds. And we just went through this. I shudder to think how much UVM Health Network spent on this process to add the new psych unit up at CDH, but it went on for months and months. And they wanted to create another 25 beds. And now we're hearing, well, we don't have a problem anymore. That's, we don't need those beds. And so that's, I really don't get that.
Okay.
Okay, I don't want to keep everybody here all night, and I don't even, if we have enough people. But if we had a forensic facility, we wouldn't have been listening, or we may not have been listening to a testimony of a person that got brutally murdered in Bennington today, correct?
I do not think that's correct. And again, like Matt Valerio, I can't discuss information
I understand.
I may or may not have obtained in a confidential way, but I don't think it's correct that this would have resolved the issue of either of the alleged crimes that we've heard about today.
So I don't want to cut you off on the argument you're making against the forensic unit, which I understand and could certainly have more of that, but it seems like a foregone, well, it's not a foregone. It seems more likely than not, we're moving ahead with some sort of forensic unit and a bill that we've been trying to make better, and would certainly appreciate your input on how we can make what you don't like, may never accept it, but we're trying to make it, better, since this seems to be moving along.
Yeah, I think that's a point well taken. And that was all I really wanted to say about that.
Yeah, no, and I respect the
Get that
points
point
that you
out.
made as well. I do understand the points that you made.
Now, there are a couple of things that were just unclear to me, and I'm not sure if they've become any clearer in the different versions of the bill. So I just want to throw them out as possibility, as questions. One is the statute does create criteria for qualifying for the forensic unit, and it's not clear to me whether the statute sets forth what the state's burden of proof is. It should be by clear and convincing evidence, and so it's very important that we make sure that that's the case, because that's the case for every other required showing for mental health proceedings.
So is that in, if I could just echo the language, is that in the section regarding the order for non-hospitalization, or are you talking about?
Yeah, I think that's where it would be.
Okay.
There's everything that Matt Valerio had to say about this safety panel, I agree with. The bill creates a government body, this government panel, that's going to make a decision about how to proceed. As far as I can tell, there's no role for the person that is going to be affected by this to have any involvement at all, to have any opportunity to influence what they do. And so I won't go into any more detail because Matt covered all that.
Okay.
There's a section about, in section six about having an expedited hearing, where if an expedited hearing is granted, it would have to be held within 3 days, and then it can be extended for up to another 5 days if it's necessary, if that time is necessary to get an independent psychiatric exam. Either the 3 days or the 5 days is too short. It's just unrealistic to be expecting people to respond to this proposed action and present a reasonable defense in that time frame. I can tell you that in the involuntary medication sections of Title 18, starting at 7624, the timeline is 7 days from filing, and then the possibility of getting an extension if necessary to be prepared for the hearing. And that's a much more reasonable timeline. There's a provision in this bill for the victim to have notice of what's being done, and then also for the victim to participate in the hearing. And I think there's a serious problem with that. Notice of what's going to happen to the person, if the person's going to be discharged. There's a proposal for the person to be discharged. That's fine. If the victim is then able to participate in the hearing, then one thing is that will put the victim in the position of hearing confidential medical information relating to the person whose custody is being sought, and that's a real problem. There's no controls over what that person does once they leave the hearing. But beyond that, the questions at that hearing relate to whether the person is dangerous to the public, to himself or others. That's not information there's no evidence that the victim can bring to that hearing that will have any bearing on that question. Sure, we know that the victim or a member of the victim's family suffered a terrible loss, and I don't minimize that. But once we get to that point, the victim is not in a position to provide that kind of evidence. What I would, there's a provision in the bill, and it's way towards the end. It's like page 31. The rulemaking provision starts at the bottom of 30 and then goes to 31 about the emergency, the involuntary procedures, and the administration of involuntary medication. And we know where this comes from because this comes from the experience at Middlesex Therapeutic Community Residence. And I don't think we should just say we're going to do this. I think we should leave this subject to notice and comment rulemaking, not come and do it from today and say, okay, here's what you're going to do. And you can do rulemaking, but we're already telling you what those rules are going to have to be. So we have a problem with that.
So it should be something along the lines of determining whether, essentially whether and how.
Okay.
Do it.
Martin, you said whether or not how, correct?
Well, whether and how essentially, I need to work on that.
Okay, all right, I just want to make sure.
But that's essentially the idea.
Yeah,
The
okay.
idea.
Another point about
Last witness.
Another point about the victim participation, again, looking at section 3, page 5, down to under D.
This is which page?
Section 3, page 5, where it provides for the court to hear the position of the victim. Again, the victim undoubtedly has a very strongly felt emotional position for what should happen to the person, but it's not what. Maybe it's. Oh, yeah, here he is, line 4 and 5.
Yep,
We don't believe that's an appropriate factor for the court to be considering. So I think those are my real points. I can tell you that in the proceedings, you know, we heard a bit of testimony about what happens in these hospitalization hearings and what happens in these other court proceedings involving someone who's charged with a crime or someone who is alleged to have a mental illness and alleged to be a danger to themselves or others. And we heard the idea that there are all these people in this hearing that are there on the side of the defendant. In reality, there's only one person in that hearing who's there on the side of the defendant. That's the defendant's attorney, either the public defender before it gets to the point of the determination of incompetence, and then the mental health law project once the person has been determined to be incompetent and is defending the person in a hospitalization here. The Department of Mental Health, the Department of, the state's attorney, all those people are not there to represent the wishes or interests of the defendant. And so I know these court proceedings can be very confusing, but everyone has a role to play, but the only player in the whole mental health system who's there to represent the wishes of the person is that person's attorney.
Appreciate that.
Thank you.
Questions for Jack? And I'm sorry we've lost a lot of our people. There are meetings that people have to go to. So,
I know those meetings, but I also have a question. Can you just say a little bit more about why you believe lines 4 and 5, the position of parties as well as that of a victim as defined, is inappropriate?
Yeah, we know the positions of the parties are one thing, because the state was one of the parties, the defendant is the other party. Clearly, the court needs to hear those. The court has to make a determination if the person is a danger, and the court has to make a determination about what kind of facility, if at all, the person needs to be in order to not be a danger. How the victim feels about it really doesn't help the court make that decision. That's really more of an emotional, going to be more of an emotional appeal than anything else.
isn't it similar to could it be similar to opportunity for victims to be heard at sentencing? I know that's a little bit different because it can, in fact, affect the sentencing potentially.
Yes, you make an excellent point, and it is very much like a victim impact sentence, this statement. And a victim impact statement goes to inform the court, to help the court determine what kind of punishment this person who has been charged with a crime and been convicted of a crime deserves to have. And that's not this situation, because this person has not been convicted of a crime. The order that this person is getting is not for punishment. The order this person is getting is to provide them with the treatment they need for their mental illness and to protect the public against any danger they may pose. So it's a facile, there's a facile appeal to that, because you can see the parallel to the victim impact statement, but that's not the purpose of these proceedings.
And I guess I was thinking along those lines, and then also wondering if I would think a victim could be might have some information about whether the person poses a threat.
Yeah, and I don't know how they possibly could, because by the time they get to this point, anything that happens, anything the person might have done is likely months or years in the past. The victim's not going to have any evidence about the person's current condition and the current danger they may pose.
So Jack, who would, if the person who is allegedly being charged, or they're being charged, but they're not convicted. Let's say they are doing so the victim family or the victim is talking about what happened to them whenever that happened. But there must be situations where there were other threats made to other people or family members. So that would come in through other potential charges, right? So otherwise
Could be other charges,
or
could be other witnesses. Yeah, there could be witnesses. You know, a lot of the time, you know, when you're being put in the forensic facility, it's typically going to be a step down, probably from jail or from hospital. And so they'll have testimony from the treating people at the hospital or at the jail about how they're doing now.
so when the judge is determining if public safety is an issue, the judge is taking lots of input, hopefully from lots of people, if there's a concern that the person may be violent again. And the victim statement, like Martin said, is more of a victim impact rather than because if they have information, either, unless it happened to them directly, it seems like that wouldn't even.
Yeah.
work.
Yeah, I agree. You know, but just as an example, one of the lawyers in my project on Friday had a hospitalization hearing down in Windham County. And someone who's charged with a crime had been placed as an inpatient for an inpatient evaluation at Vermont Psychiatric Care Hospital. And so the main witness from the state was the treating psychiatrist up at VPCH. And that's the kind of testimony we'd expect to see in these cases.
Go ahead, yeah.
So I'm just wondering, because it sounds like for victims, being seen and being heard is so important that I'm wondering, you get to see this a lot. Is there something else that would make sense to like should victims always be sort of acknowledged as like, I mean, it seems silly to put that in the law, but because it seems like, why wouldn't somebody notice them there? But are there meaningful things that you think, from your perspective, we could be doing so victims don't feel so like outnumbered of like 10 people are here associated with the defendant, but I mean, and again, you explained what their roles are, but I'm just wondering how to do some, replace it with something meaningful to victims rather than the danger.
Well, what happens in a criminal case, what happens in the criminal division of the court is a public procedure. And, you know, the competency hearing is a public hearing. Even the hospitalization hearing is a public procedure.
So a discharge hearing is as well, or?
I think so.
Yeah, okay. So there shouldn't be a concern about the victim getting
But, you know,
medical information.
we're talking about, well, there may be a way, I should think about that because I'm not sure how that works. But, you know, I get that you're talking about sort of a symbolic gesture to the.
Right, or meaningful, you know, right.
And
That isn't.
And I think about balancing that against the concrete rights of my clients. To
Sure,
have
right, yeah.
a hearing that, and a decision that's based on purely on the facts and evidence presented.
No,
So I don't think I'm going to satisfy you.
okay, I just was trying to think of a way to
Angela?
Speaking of balance, is there, speaking of I never attended one of these hearings, of course, but at a discharge hearing, you mentioned that the types of witnesses you would expect to hear from. Wouldn't those be the people who were saying this person should be discharged? There wouldn't be a counter, right?
There potentially would be a counter because there is let me just go through here to be sure I know what I'm talking about. But
Maybe clinical factors would be presented by the mental health experts, and then dangerousness factors might be presented by the prosecutor.
yeah, and what I'm thinking about is that if you look at 4821 on page 2, going to the bottom of page 3, it says procedures for hearings for persons with a mental illness shall be as provided in 18 VSA chapter 181. And that chapter includes the right of the state's attorney to get their own independent psychiatric exam. So if they don't agree with the proposal to discharge the person, I believe that they have the ability to get an independent psychiatrist to take the opposite view. And if they get that opinion that is what they're looking for, then they would present that witness. In fact, I just had a case again last week where it was a long-running case, but the state's attorney could have but did not get an independent psychiatric exam. We wound up resolving that case, but without going to hearing, but that's where it was.
Yeah.
So I'm happy to stay as long as we're all.
No, I think we're probably good at this point. And like I say, we will be having some sort of other version by a little later this week. And we'll invite folks either provide written testimony, or if they need to come in to talk to us, can do that as well. So we are going to adjourn until tomorrow at 9, at which time we're going to have votes on 3 things, S-36 and 2 bills that we received over. And if Stuart, I was hoping that Karen could stay on as well, but